Singapore is a step closer to a new law that will protect employees from discrimination at work. 20 recommendations by a tripartite committee were accepted by the government today. Clara Lee explains what that would mean for you and me.
Now, here are 5 key things you need to know about what could go into the new workplace fairness law. For starters, employees will be protected from 5 different characteristics of discrimination, namely age, nationality, sex, race and religion, and disabilities or mental health condition. The protection starts from when someone reads a job advertisement while on the job and all the way up until retirement, essentially every step of the way. Number 2, mediation is priority, but a case can be brought before a tribunal as a last resort. Errant employers may be named and shamed or forced to pay a compensation of up to $20,000 or have their work pass privileges suspended. Number 3, employers won't be able to exact revenge on complainants and whistleblowers. If they do, enforcement action will be taken. Number 4, 2 vulnerable groups will be exempted. What this means is that employers can favour seniors aged 55 and above and persons with disabilities or PWDs. An advisory will also be issued to employers to support PWDs at work. Ultimately, the aim is for a more harmonious workplace, a point made at the media conference.
Fair employers will have a more productive, a more engaged workforce, a more harmonious workplace, and be better able to attract and retain talent, contributing to stronger and better business outcomes.
And finally, when will this all kick in? Well, the plan is for the draft law to be tabled in Parliament next year, but it'll be a living document to be refined and reviewed as we go along.
The tripartite committee, which deals with discrimination cases, says it expects more cases to surface before it tapers off. That's due to greater awareness of the issue. The committee receives an average of 315 complaints a year. The National Trades Union Congress says it's prepared to handle the workload.
There's a whole plethora of things that we have been championing, and we will continue to do so, regardless of whether the cases actually will go up or go down, or in the longer term taper off. Because we believe, as I said in the 3-prong, legislation is a last resort. And whatever outcomes of the legislation, whether awareness goes up, doesn't change the whole landscape that NTUC believes in pushing for a fairer workplace for all the workers.
A federation representing local employers welcomes the potential new law. It believes a fair working environment can lead to greater productivity. Despite reservations from some firms, the situation might lead to frivolous claims being made.
As an employer, heading employers federation, I think it's always a very difficult say, why are we agreeing on this? We all prefer no legislation, because for businesses, we like agility, we like flexibility. Okay, but some form of a rule to encourage the right behavior, I think, is also very important.
How does it feel to experience discrimination at work? We speak next to someone who reported facing that and wishes to be known only as Miss X. Miss X, thanks so much for joining us this evening. What did you experience at your workplace?
Yeah, hi, good evening. Okay, I work as technical assistant since 2020. I am a single parent and a sole breadwinner of the family. So I have 2 kids. I have 1 daughter, which is 6 years old, and 4-year-old son. I always have a good relationship with my company because they showed empathy to my situation up until they terminated me through email with 2 months notice. Then I felt confused and shocked, so I replied to their email accepting the termination. But I detailed out my specific job scope during my notice, as I previously took a heavier workload than what is stated on the contract. The company was unhappy at my response and subsequently terminate me again with immediate effect. So for this, I really felt unhappy, so I sought assistance from SCWO, and they referred me to TADM for mediation with the company. And then SCWO helped me to prepare for a mediation process, going through the facts of the case, and also SCWO helped me to boost my confidence, because I'm really scared also. And they also provide me a counseling support on how to handle it emotionally.
Right. Sorry, Ms.
Yeah?
X, for cutting in here.
Sure.
As you've just laid out, it's quite a long process. And it's a process in which you are very likely to lose confidence at many different points. Because first, you aren't even sure legally what you are entitled to at any workplace. At which point were you certain? Was it after, during counseling, that you were certain this is discrimination and therefore a point at which you can actually address this formally?
During mediation, then only I found out that I was terminated due to my personal issues, including the caregiving, because they told me that I'm out of work, although my leaves are within the numbers that, I signed in my contract.
So this, pardon me, then this proposed law on workplace fairness, do you think if it had been in place for you and you had been fully aware of that in your company as well, could it have helped prevent this situation from happening in the first instance?
Yes, that's right. I think the newly law will help a lot of women, especially my situation, or a lot of people, because, they have the guts to, or confidence, because we already have a law and they can refer to this law.
Oh, thanks so much for your time this evening, Ms. X. Ms. X is a mother of two who faced discrimination at work. And we also have with us Mr. Sim Gim Guan. He's Executive Director at Singapore National Employers Federation. Welcome to the program. Mr. Sim, thank you for joining us. We have just heard from Ms. X, her case, what she feels facing discrimination because she felt she was terminated under conditions she felt were not fair to her because she needed to give that much care to her two children as a single parent. Workers and employers, they have misunderstandings. They may be genuine, they may not be genuine. How do you establish that actual discrimination has taken place?
So maybe under the proposed legislation, discrimination would have taken place if there is an adverse employment decision because of any of the protected characteristics. And certainly there will be a need to look into the specific of the case. Actually, even before the workplace fairness legislation is put into place, today, under the tripartite guidelines for fair employment practices, there are already measures being taken to ensure that our workplaces do not discriminate and continue to embrace fair employment practices. Any individual that have a case that they would like to bring should actually reach out to TAFEP. Together with the TAFEP leading and helping the individual, I think as in the case of Ms. X, I think there will be advice that is going to be provided to the individual. And if the individual is unionized, certainly they can reach out to their unions as well.
All right. One of the 5 key points raised in our original report on this workplace fairness laws would be mediation is priority, but as a last resort, a case can be brought before a tribunal in which errant employers may be named and shamed. Let's say in the instance where mediation fails, is there any way to appeal that decision? Can this be settled in a less formal way at any way along, or once you start, are you stuck in exactly the same path all along the way to a full tribunal?
Okay, so actually, one thing that we are very clear is that we want to continue to preserve a harmonious workplace, and we do not want to build a litigious workplace culture, which is why one of the key recommendations is to require employers to put in place proper grievance handling processes. And if they are able to do so, actually you allow employers to better manage workplace grievances that could arise out of misunderstanding, for example, and continue to build a more inclusive and harmonious workplace. It is only if the issue cannot be addressed within the company, then the issue will reach TAFEP for mediation. And with mediation, actually attempt will be made to try to, of course, resolve the issue. And it is only if after mediation, it is found that the issue can still cannot be resolved, then they will go to the Employment Claim Tribunal as a last resort. And once the tribunal makes an order, there are only limited conditions under which an appeal can be made. For example, if it's a matter of a law, or if the issue is outside the jurisdiction of the tribunal.
All right, the problem is many things lie outside absolute jurisdiction. So, for example, you talk about a harmonious workplace. For example, someone who has raised a complaint, brought that to a tribunal and stays on in the company. There is part of this new law. Employers will not be allowed to exact revenge on complainants and whistleblowers. But still, a harmonious workplace, that is very hard to aspire to after all the things that have happened between employer and employee. Are there any measures in place beyond just legal measures to mend ties?
So actually, under the proposed legislation, it is indicated that employers should not take retaliatory action against individuals who have come forward. That is to give assurance to individuals that may encounter discriminatory practices so that they are prepared to come forward and state their case. And as I mentioned earlier, if there is a proper grievance handling process, then it is possible to ensure that the process is a fair one. And it being a fair process, it will be fair to all parties concerned. Both the person that have faced discrimination, as well as perhaps the person that have perpetuated certain actions. And of course, the attempt from the company's perspective would be to continue to try to be fair, to have responsible employment practices, to be fair to all parties concerned. Because it's important that employers do so, because if they don't, then the other employees that are in the workplace would also not find the workplace to be a good workplace that they want to be working in. So a good, harmonious working environment is something that I think all employers will strive to preserve. It is certainly possible to anticipate a situation where there could continue to be tensions, but I think it is important that then attempts are made to work through the issues that individuals might have amongst colleagues.
All right, thanks, Mr. Simo. Stay with us. We will be returning to you for more insight. But for now, let's take a look at a report on how some firms have started strengthening workplace fairness on their own initiative. Clara Lee finds out how hiring mature staff has actually benefited one company.
At 57 years old, many would consider this bus captain a senior employee. But in this transport company with more than 1,000 workers, C. Elankovan is not the oldest. In fact, nearly a third of Go Ahead Singapore staff are aged 55 and above, and almost 70% are at least 40 years old.
I'm feeling very happy when more older workers in our industry, because more easier to we talk, then they more easier they can understand. We can easier to do any teamwork.
The company says hiring more older workers wasn't intentional, but it's been reaping the benefits of doing so. A more experienced team means incoming rookies get proper guidance. It adds that not many employers realize the value they bring.
I would think that it's only fair to consider mature workers and not stereotyping to say that they may not be as good in terms of learning or so. Our experience is our older workers, our more mature workers, they're more willing to learn actually. Yeah, so I think the culture of the company is very important to give them the opportunity to engage them more, to talk to them more, to understand more.
The firm is also going the extra mile to retain its older hires. For one, it's sending them for upskilling courses and encouraging healthy habits by circulating health bulletins each month. But the company admits that it's not a case of hiring older workers just for the sake of it.
We don't stop hiring regardless of age, be it mature or young workers. So as long as they are passionate to the job, they are competent for the role, we will assess them equally and then offer them a job.
Still, she says other employers shouldn't hesitate to make the jump and start hiring more mature workers.
Mr. Sim Gim Guan joins us again now. He's Executive Director at the Singapore National Employers Federation, speaking to us from Singapore. Now, Mr. Sim, we just saw a company. Now, according to that company, their hiring of older workers is not intentional. They're not hiring older workers just for the sake of it. But under this new proposed law, there is clear and explicit protection against discrimination based on age. For those who are, say, below 55, could they then argue there is now discrimination against us because this law does not explicitly favor protection for us?
One of the issues that the tripartite partners have been driving is to promote and facilitate employment of senior workers, because we do recognize that it is a positive outcome for society, and especially for seniors and also persons with disability. They may have greater difficulty. So the recommendation is to allow employers, if they wish to hire persons with disabilities or seniors, to be able to do so, provided the individuals concerned are able to meet the basic requirement of the job. And once they are hired, actually what happens whilst in employment continues to be based on merit. So it is only at the point of hiring that we are recommending that there will be greater support given to employers that wish to do so.
All right, for 5 different kinds of discrimination from which employees are protected, they are specifically age, nationality, sex, race, and religion. But there are some other forms not explicitly covered under this law, such as sexual orientation, political affiliation, just to name 2 of them. You could think of others. Does this mean employers can choose to be biased against people who, say, openly profess perhaps allegiance to these types of things that are not protected under the law?
So maybe to reiterate that all forms of discrimination should not be practiced by employers. Currently, under the tripartite guidelines for fair employment practices, that is already covered. So that continues to be covered. The new legislation will sit on top of the existing tripartite guidelines for fair employment practices. It's just that even as we are going into legislation, the committee has recommended that we take a more focused approach, looking at issues that are more common. In fact, the 5 protected characteristics covers about 95% of all the cases that today are reported to TAFEC. So with a more focused approach, I think we will be able to ensure that the employers will be able to ensure that their practices are in alignment. But at the same time, even as they are meeting all the new requirements under the law, the TGFEP continues to undergird our workplace fairness practices.
All right, thanks so much for spelling all that out, all the details for us. Mr. Sim Gim Guan, Executive Director at Singapore National Employers Federation. Thank you for joining us this evening.